So I will give you a very, very short introduction into the history of international arbitration with a special focus on the trend towards more transparency. And speaking of international arbitration, we normally understand three kinds of arbitration under this umbrella. So first, arbitration among states, interstate arbitration. Then second, investor-state dispute settlements, also often before arbitrational tribunals. And third, commercial arbitration. By transparency, I understand the accessibility of what's going on at the arbitral tribunal by the general public, as a rough starter. On this slide, I'm showing you an important provision of the United Nations Charter. Article 33 UN Charter speaks about the peaceful, pacific settlement of disputes. And if you read this provision, many of you probably have read it before, you will see that it's a list of dispute settlement means. It's an open-ended list. And it contains, after negotiation, inquiry, mediation, conciliation, also arbitration and judicial settlement. So this provision makes a difference between judicial settlement and arbitral settlement. And actually, this distinction in the domestic sphere, on the level of domestic law, is pretty clear. Arbitration belongs to the private realm, while judicial settlement is in the public realm. The reason is that courts are institutions of the state. They are the third branch of the state, besides executive and legislative branch. And they work based on the rule of law. And here, access to a judge is a key element of the rule of law. In states, in every legal dispute among natural persons or in disputes against the state, if the state is a state under the rule of law, a court must be available. That's the right access to the judge. So judicial settlement is an element of the state's monopoly of the legitimate use of force. In contrast, speaking of the domestic sphere, arbitration, I characterize it as private because it's governed by the principle of party autonomy. It is based on the consensus of the parties, and it is voluntary. The party autonomy in arbitration concerns the choice of the arbitrators and also the choice of the applicable law. So the question is whether this clear distinction between arbitration as something private and judicial settlement as something public, whether this distinction also holds in the international realm. That's my question, but we decided before, because of technical reasons and so on, I would like to deliver this as a lecture, but I'm asking questions for you to think about, and we can discuss and maybe find answers to the questions a bit after the lecture. I think that's, for technical reasons, the best way to proceed. So the whole topic is whether this distinction makes sense, speaking of international or transnational arbitration. So actually, why do we have arbitration? Why are you interested in that? Because supposedly arbitration has several practical advantages over judicial proceedings. It's supposed to be cheaper, it's supposed to be faster, and it is confidential as opposed to public. And Professor Krivoy spoke about that this morning. However, all of these supposed advantages are maybe only supposed if we look at the facts. Because speaking of cheaper, actually, arbitration can be pretty expensive. For example, costs in investor-state dispute settlement can run up to several millions of dollars. I think the fee for a member of an ICSID commission of investor-state investment settlement dispute can be per day. It's a fee of $500 per hour, which for one day makes 4,000 US dollars for an arbitrator. And the party councils, of course, have a higher fee. You can ask Dr. Oettinger afterwards. And so I just looked up a recent dispute in the case Access Business Group versus Mexico, which was decided in 2025, a recent award. So here the cost for the complainant was $3.5 million, for the respondent $1 million, and then $690,000 fee for the tribunal. So I don't know whether this is cheaper than judicial settlement, probably not. Question whether arbitration is faster, also this is doubtful. The average for investor-state disputes settlement under ICSID is an average of 4.6 years. The proceedings before or hosted by the Permanent Court of Arbitration are also not much quicker. In comparison, the proceedings before the International Court of Justice, so judicial interstate proceeding, here we find an average of 4 years. So I doubt that arbitration is mostly faster. Third point, and this is, of course, the most important characteristic, the topic of this lecture, is the question of confidentiality, or as Professor Petrick said, secrecy, as opposed to publicity or transparency of court proceedings. So my talk will be descriptively about the question of how transparent has arbitration become over time, and then normatively the question whether this is a good thing, whether it is appropriate. Before talking more about transparency, I will walk you extremely quickly through the history of international arbitration, and I understand you also have received some reading, and I hope you did the reading, namely an entry in the Max Planck Encyclopedia of Public International Law by Charles Brouwer on arbitration, which is not very new, but it is an excellent overview. So I hope you are already quite informed about some basics. Key events have been first milestone in 1794, the Jay Treaty arbitration. This was an arbitration after the independence of the United States from Britain. The US, as you know, declared independence in 1776, and then a peace treaty was concluded in 1783, and this was the so-called Jay Treaty. And in this context, there were still a lot of disputes to be settled. For example, on the exact location of the boundary between the United States and Canada, and also there were a lot of claims by British merchants for debts incurred by United States citizens before the peace treaty was concluded. And there were also complaints by US citizens against the irregular seizure of vessels. So all this had to do with the War of Independence and the independence. And on the basis of this treaty, an arbitration tribunal was set up, and this was a milestone, or it was basically the first prominent example of an international arbitral tribunal, because it was a collegial tribunal. So there were several persons. It was not only a king or the pope or so. It gave reasoned awards, and it gave decisions based on international law. However, there was still one limitation, namely the arbitrators were only nationals of the two conflicting states, United States on the one side and Britain on the other side. And this was still a feature of diplomacy because it was still among the parties in a way. There were no arbitrators from other countries like Switzerland or so. Second milestone, 1872, so almost 100 years later, the Alabama Claims Arbitration. Again, the same parties, actually, the United States and the United Kingdom, after the Civil War in the United States. Actually, and here, this was also had to do with a war, but this time it was the Civil War in the United States, the northern states against the southern slaveholding states. And here, the US complained that the United Kingdom had violated the international laws of neutrality during the US-American Civil War by allowing that ships were built for the Southerners in Britain, actually. And warships that were then built in the British ports and used in the Civil War. And this was a violation of the laws of neutrality. That's what the US claimed. And here, again, there was a tribunal of 5 members. And actually here, only 2 members were appointed by the parties, so one by the US and one by the UK, and the other 3 members of this tribunal were appointed by 3 kings, or 3 sovereigns. One was the president of the Swiss Confederation, and then the King of Italy and the Emperor of Brazil, they appointed the arbitrator. So it was an element which was a bit more in the direction of internationalization, and the outcome here was that the United States won against the UK for direct injury to US commerce. After these 2 milestone arbitrations, during the 19th century, around 100 disputes among states were settled by arbitration. And then there was also the development that arbitration was already foreseen in treaties and not only organized ad hoc after the problem arose, but we find already in 19th century treaty provisions, compromissory clauses that already foresaw an arbitral tribunal. However, as also Brouwer says in his entry, there were still limits to the quasi-judicial character of arbitration because the arbitrators were not really independent or not necessarily independent. There was also no challenging of arbitrators, contrary to nowadays, where we have frequent, for the taste of many observers, too many challenges against claiming that an arbitrator is not sufficiently independent. That was not yet the case in 19th century. Now, speaking of the transparency, especially the Alabama claims arbitration was strongly covered by the press. For example, the submissions of the United States were summarized in the newspapers in an early stage. The strong media coverage was kind of, well, the arbitration was a good story for media because it was an issue of very high national interest, and also it could be combined with celebrity stories. So the press was really a very important resonating body already. But of course, the press of each side reported with quite a strong national bias. Already at that time, there were some doubts whether a world opinion really existed and could express itself and be informed about such arbitration. But let's move to the next arbitration, which I like most from the 19th century, famous cases 20 years after the Alabama arbitration. Again, the United States and United Kingdom were involved, so I think we can speculate about why the 3 very first arbitrations involved these 2 states. This was now about the rights of jurisdiction of the United States in the Bering Sea and the preservation of fur seals. And as you know, the Bering Sea is on the US west coast, between the US and Russia, and actually also of current interest, of course. You remember that Alaska was bought by the United States from Russia in 1867 for $2.7 million. And as you know, buying territory is now quite fashionable again, but so far it hasn't worked out. So the US claimed exclusive jurisdiction over the Bering Sea, but the United Kingdom wanted to also catch and hunt seals there. And the outcome of the arbitration was that the tribunal declared the sea or parts of the sea to be international waters, so that the United Kingdom also was allowed to hunt there. And then there was also several treaties concluded for the protection of the seals, but not because people liked them, but in order to protect them as a resource, so that they would not go extinct, so that the industry could go on in a more sustainable way. But actually all that didn't work, so it was counterproductive, but that doesn't have anything to do with the arbitration. Actually, here in this arbitration, the arbitrators already consciously addressed the issue of publicity of the hearings at the beginning of the proceedings, and they also made some arrangement for public access. Next milestone are now two very important conferences. You surely all know them. In 1899 and in 97 in The Hague, two peace conferences took place. These peace conferences dealt with the laws of war and also with peaceful dispute settlement, because of course these two things go together. The need for peaceful dispute settlement is the consequence of trying to outlaw or at least to contain war at that time. If states are not allowed to resolve their disputes with military force, they should find some other means, and therefore, that's the idea, they should go to an arbitral tribunal. And in 1899, therefore, the so-called Permanent Court of Arbitration was founded. It still exists. It has its seat in The Hague, but unlike the name, it's not really a court, but it's more like a bureau or a secretariat. It has or runs a list of arbitrators for ad hoc arbitration, and it also provides rules of procedure, and I'm sure you're also going to have a lecture from the PCA. So, for example, I am on the list of arbitrators for Germany, but nobody ever asked me to do an arbitration. So this list, states are not bound to pick people from the list, but the PCA offers a lot of interesting services. Then in the same year, a Hague Convention for the Pacific Settlement of International Disputes was concluded. This convention is no longer in force because it was replaced by the Second Convention of 1907. But actually, I mention it because it's interesting. It already, in 1899, contained rules on transparency, although the word transparency was not used. For example, the convention said arbitral awards were to be announced publicly. However, the importance of the Permanent Court of Arbitration waned a little bit because after First World War, the so-called Permanent Court of International Justice was created together with the League of Nations. So here we have now this is a shift or a jump, you could say, from arbitration to a court. 1922, this court was founded, and one reason was that the German Empire had been defeated in First World War. Germany was against judicial settlement as a big power, like nowadays China and the US. They are also against judicial settlement, or as China and the South China Sea arbitration, they don't recognize or don't accept an award. So this court, the PCIJ, was then, after Second World War, succeeded by the International Court of Justice, which is now the so-called World Court for Interstate Proceedings in The Hague. It sits in the same building which was built in 1920 for the PCIJ. At first, it looked as if the Permanent Court of Arbitration, this bureau also sitting in The Hague, was therefore not so important. However, after 1990, the big political shift in the world, the collapse of the Soviet Empire, which led to a lot of activity on the international level, and it also led to a kind of renaissance of the PCA. For example, we have pending cases. I looked up the website of the PCA, which mentions the current pending cases or the cases which are kind of organized to a varying degree hosted by the PCA. And they mention 8 interstate arbitrations, 92 arbitrations under investment treaties, 93 arbitrations under contracts, private contracts involving state or another public entity, and then 7 other proceedings. Recent example, a pending case between Rwanda and the United Kingdom on the asylum arrangement that the 2 states concluded, where the idea is to deposit applicants for asylum in Rwanda. So I haven't looked up I don't know the exact details, the controversial issues, but this is an arbitration just now pending. It has been instituted in November 25 before the PCA. But the PCA is more active and more important even for investor-state arbitration. The Rwanda-UK is an interstate arbitration, but there are many more investor-state arbitrations pending before the PCA, currently 92, as I mentioned. For example, currently we have a case, Hasenberg Aktiengesellschaft against Lithuania. But this Aktiengesellschaft, supposedly sitting in Zug, seems to be a straw firm by Russian oligarchs and now sues Lithuania. And this has something to do with the sanctions against Russia. I don't know, it's not, there are no public, well, there's not much more public about that, but I found it a quite interesting pending case. I would like to mention another form of arbitration, which is also very important and which has been called mixed arbitration. Here on the slide, I mention arbitration between private persons on the one side, instituting proceedings against states on the other side. These proceedings, I would like to call them diagonal, so you can imagine, so you have the private person claiming to be injured against a state, and these tribunals were often called commissions, but I think the name is not important, whether you call it a commission or a tribunal, and the abbreviation TAM, Tribunaux Arbitraux Mixtes. So these were mixed arbitral commissions or tribunals, and I think actually they were called mixed because they were always also staffed with arbitrators from both sides. But the main feature, which is more interesting, and that's why I put them all on this slide, is this fact that individual private persons, so natural persons or firms, often not only investors, but commercial actors of all kinds, they could, already starting with the very famous arbitral tribunals after the Mexican Revolution, which was from 1910 to 1920, against states. And I think it's very important that here, even before First World War, individuals were able to attack states without having to wait for diplomatic protection from their home state. But they could take their interests that they claim to be injured through war activities in their own hands and reach tribunals. Same also under the Peace Treaty of Versailles. There were a lot of complaints by citizens from countries like Belgium, France, and so on against Germany. Thousands of claims were decided in these diagonal arbitrations. Another group of diagonal arbitrations are, of course, disputes about concessions of resources, mostly oil, starting in the 1940s to 1960s. There are a host of famous arbitral proceedings instituted mostly by transnational companies like British Petroleum, aka BP, Texas Overseas, aka Texaco, and so on, against host states. And you can think of who were these host states. These were countries like Saudi Arabia, Iran, Libya, Kuwait. And these arbitral tribunals, they created an interesting case law. The third I mentioned on the slide is ICSID. I already mentioned. ICSID is the abbreviation for International Center for the Settlement of Investment Disputes. This center has its seat in Washington. It's under the umbrella of the World Bank. These are investor-state disputes based on the ICSID Convention, which offers the rules for conducting such investor-state disputes. This convention already dates from the 1960s, but it has really come to life only in the 1990s, with a lot of states acceding this convention, but it has also attracted a lot of criticism. One point of the criticism is the lack of transparency and confidentiality, but other kinds of criticism concern generally the supposed or felt or real imbalance in favor of the investors. So host states which have been condemned, in quotation marks, to pay millions or billions of damages to investors, they have partly even drawn the conclusion to leave the convention. For example, Bolivia in 2012 and Venezuela in 2012 denounced the exit convention, Ecuador too, but came back. So this means that denunciation or reaccession is also is a political question depending on the opinions of the government of the state. So this criticism has also triggered some reform attempts, at least, and I'm also sure you'll have a class about that as well. The fourth that I mentioned is the Iran-US Claims Tribunal. It was established after the Iranian Revolution, 1978, so this seems really ages ago. However, this is quite current, not only because we now witness an upheaval in Iran, but also because this Iran-US Claims Tribunal is used as the model for a claims commission that is being established with regard to the Russian aggression in Ukraine. There is already a registry of damages that has been set up in form of an enlarged partial agreement with the Council of Europe. And so the damages are already registered, and there is the idea that there will be a point where these damages may be settled, and the basic model has been the Iran-US Claims Tribunal for the institutional design of this planned settlement. So this is now the really super official history of arbitration, and I would now like to zoom in a little bit more into transparency in international arbitration. And first of all, recall what transparency means. Transparency is case-related or the fact that case-related information will be given to external actors who are not themselves involved in the arbitral proceeding. Case-related information. And this case-related information basically takes three forms, but I will talk only about two forms. First, access to the documents. And of course, there are various types of documents, submissions, awards, etc. Second, access to oral hearings. A third form of transparency can be seen in the allowance of amicus curiae briefs, because such briefs from friends of the court or of the tribunal in this case, this also means that, for example, NGOs or other experts will influence the proceedings and will then also publicize their amicus curiae brief. So this is also a type of transparency, but I think it raises really special and additional problems. There is also a trend towards more admission of such briefs, but I will not talk about this. So first question, of course, actually, what is the rationale? What's the purpose of transparency in arbitration? Because after all, we said at the outset that the basic idea is that arbitration is confidential, and that's a good thing for the parties. However, transparency might also have some benefits and might be needed. So complete confidentiality and secrecy is maybe not the right thing. And I would like to discuss several functions or rationales of transparency in international arbitration. First, the first rationale was, or the idea was, already in 19th century, already voiced by famous philosophers such as John Stuart Mill or Jeremy Bentham. They already thought that publicity would foster or promote compliance with the awards of a tribunal. The idea that these philosophers, and also others of course had, was that publicity would be a means of controlling and also of checking the domestic governance, because it would appeal to the, let's say, feelings of justice of ordinary citizens, that what the tribunal did and everything about the dispute would kind of stir interest, and then the opinion of the public would sanction a government that did not comply with an award. That was the idea, that governments would be pressured into compliance for fear of losing reputation. For example, William Ladd, the founder of the American Peace Society, wrote about public opinion as the queen of the world. Actually, it's important to remember that at the beginning of the 20th century, there were strong civil society movements. This is not only a phenomenon of the present. The peace movement was the most powerful civil society organization. In 1908, Elio Root, he was the winner of the Nobel Peace Prize. He gave his Nobel Prize speech about the diffusion of knowledge and information about other countries, that this would improve international understanding, and that this would gradually create a community of nations, and that the worldwide public opinion that would condemn nations for violating international standards would be an important force. Already at the beginning of the dispute, that this public opinion would kind of like force states also to go to arbitration. At least this is what Root thought. I think it's important to recall that, especially in 19th century, but also now, there is a kind of a basic tension between the need or the desire to respect the sovereignty of nation states on the one side, and on the other side, the need to settle the disputes peacefully. And actually, I should have said that at the beginning, maybe, arbitration was a kind of a compromise between safeguarding the sovereignty of states, but also offering a means of settlement. Because arbitration was, given that it's completely based on the consent of the states, and that the states have a lot of influence choosing the arbitrators, choosing the applicable law, plus the confidentiality. So arbitration was considered to shield the sovereignty of states still to a relatively high degree, but nevertheless allow for settlement. In a way, transparency was also a kind of a substitute for the lacking of hard enforcement. Again, this is something I should have said at the beginning, but you also know it, that there is no police, there is no enforcement of judgments or award in the form of compulsory like seizures or whatever. All this is not possible on the international level, and the pressure of the public opinion is therefore a substitute for the lack of other types of enforcement. In a way, a soft sanction. That's at least the theory or the idea. And we can maybe also discuss whether this soft sanction of public opinion is still relevant for compliance and effectiveness today. Second rationale or function, expected function of transparency is the fairness of the proceedings. On the slide, you see the preamble of the Mauritius Convention of 2014. This is a convention which concerns the transparency of investor-state dispute settlement, and it is based on or linked to the United Nations Commission of International Trade, the UNCITRAL transparency rules. This UN commission has created, and I gave this to you also, I hope at least in the reading material you got it, a set of rules to improve the transparency of investor-state dispute settlement. This was in 2014. And the UNCITRAL rules, because they were adopted in 2014, they say, okay, we apply only, these rules apply only to arbitral proceedings that are based on treaties that entered into force after 2014, because the UNCITRAL rules could not claim to have a retroactive effect. But of course, there are a lot of arbitral proceedings that are based on treaties before 2014, and therefore the Mauritius Convention was supposed to close this gap. The Mauritius Convention says that unless the parties don't agree, as a fall gap, the UNCITRAL rules will apply also to arbitration based on older treaties. But why I mention the Mauritius Convention here is mainly because it gives in its preamble one explanation for the need to improve transparency. Namely, the preamble says, believing that the rules on transparency contribute significantly to a fair and efficient settlement of international investment disputes. So the idea is that transparency guarantees or helps to produce more fairness of the proceedings. The Mauritius Convention has been ratified so far only by 9 states, among them Switzerland and the European Union. So the majority of states in the world apparently don't buy into this or have some other problems with the claim that transparency contributes to fairness. So the question is, of course, why should transparency contribute to fairness of the proceedings? The answer is, well, the expectation is that transparency will help control bias of arbitrators or even discipline their misconduct, and it will also be able to secure a better quality of the evidence. That's the contribution to fairness. The next function of transparency is that if the awards and even the entire proceedings are made public, then this will help the tribunals to refer to the case law of other tribunals. Because, as you know, I guess you heard this afternoon already, the big problem of arbitration is, of course, that there is no uniform system in which the tribunals would have to listen to each other. Each tribunal is a small cosmos and can do what it wants, basically. Therefore, there is no harmony in the case law. So, but if the tribunals can see what the other tribunals did, then there is the hope that they will kind of try, in a way, bottom up to form a more coherent system. And this might set in motion what colleagues of mine, August Reinisch and colleague, called a clarification spiral might be set in motion. If we have more case law that is visible, then we have also more legal certainty, and this will then also reduce the number of disputes, because if the law is clear, parties will not go try to go to a tribunal. So again, we might discuss whether this works or not. The fourth function, the expected function of transparency, is the increase of democratic legitimacy and accountability. Why and how? Because the idea is that more transparency generates more public trusts, and therefore this will be an increase of social legitimacy. The question is, of course, does arbitration need democratic legitimacy? I put it in brackets on the slides. And because actually the basis of arbitration is exactly not democracy, but the basis is the party autonomy and their consent. Therefore, one could say, wait a minute, democracy doesn't really fit for arbitration. Maybe it also is not relevant for judges, and I would maybe like to discuss this question with you, because I think that's really a key question, whether we need democracy here in arbitration, and whether there is a difference between the democratic basis of a purely domestic law judgment inside Switzerland or whatever state, and on the international level. I think there is a difference, mainly because on the international level, it will be very difficult to correct and change or override an arbitral award through a law. Because on the international level, we don't have a parliament that makes laws. Like here in Switzerland, if a tribunal or a court issues a silly award, then parliament can act and then they override it by a law. Does that work on the international level? Not so easily, I think. And therefore, we need some other form of democratic or quasi-democratic counterbalance or control, one could say. Yeah, that's a thing I really would like to discuss with you. So just to close, I would briefly like to, without going through more slides, like to speak about some concrete regulation of transparency. And I gave you the material, examples of rules on transparency, for example, the UNCITRAL rules I mentioned, but also the transparency rules of the Permanent Court of Arbitration. So you can look up these details, and I don't want to walk you through them here in this keynote. I just want to recall like some parameters. So first of all, I think it's important to distinguish between the access to the documents and the access to the hearings as the two basic forms, right? And in the various rules I gave you, the details are organized differently. If we look at the documents, the transparency of documents, of course, we have to look at the exact object of transparency. So which documents are we speaking about? Then the question arises, under what circumstances does a tribunal may or must a tribunal give access to the documents? Then, of course, there's the question of timing. When should access be given to the documents? Then there is the question, who should make the decision? Who gives access? And then finally, how should this be done? If we look at the various documents that are created during an arbitral proceeding, we have, of course, the awards, but before we have all kinds of decisions, orders, directions, and so on of the tribunal. We have minutes or records of the hearings. We also have the pleadings and other written materials. We have the correspondence between the parties. Speaking of transparency of documents doesn't mean that all this will be treated equally. Generally speaking, the arbitral awards are something where more transparency is currently the habit, let's put it like that. So, for example, the rules of the Permanent Court of Arbitration, they say that the awards will be published with the consent of the parties or when required by a legal duty. This is also interesting because sometimes such a legal duty might arise from domestic freedom of information laws. I think that this then could also shape the arbitral proceedings, but I'm not 100% sure about how this interaction works. But generally speaking, we can say awards are generally more publicized than other documents. But for example, the written submissions of the parties. Sometimes one party decides to just put its submissions on the web. Then what's the reaction of the other side? Typically, the other side will then also put its submissions on the web because it thinks that will be in a disadvantage. So there are some strategic games that are possible here at this point. Then the question of timing, of course, I think there is a big difference between publication during the proceedings and after the proceeding. Because, of course, during a pending proceeding, a lot of considerations speak against wild, free-floating transparency, because the orderly procedure might be damaged by such an early publication of documents. Once the proceeding is over, these considerations are no longer relevant, so it seems much more easy and acceptable to publish all kinds of documents once the proceeding is closed. Then there's, of course, also the question, who should decide? Mostly it's in the discretion or competence of the arbitral tribunals to decide about the degree of transparency, what and when and how. So it's considered to be part of the governance of the tribunal over its own procedure. And then there is, of course, also the question of the transparency of the hearings. So first of all, a question whether to have a hearing at all, but assuming that there is a hearing, then there is, I think, a huge difference between courts and arbitral tribunals. Namely, for courts, we have a presumption that the proceedings are open to the public. For example, you can go to The Hague and you can listen to the hearings there. Whereas for arbitral tribunals, there is kind of the fallback rule is different, that normally they are not public, but the courts, the tribunals may authorize the public. And here again, depending on the concrete rules, under which rules the proceeding takes place, there are nuances. Then there's, of course, also the question of more general publicity in form of live streaming. And this international courts and tribunals have also made some experience with such live streaming. For example, before the international court, the tribunal, ICTY, international, ICTY, wait a minute, ICTY, International Tribunal for the former Yugoslavia. I don't know why, for some reason, I don't get the abbreviation now. In any case, the Yugoslavia Tribunal, which is a criminal tribunal for war criminals during the civil war and secessionist war in Yugoslavia. There was one incident that one accused committed suicide before the running camera. That was a horrible incident. So since then, the tribunal only live streams with a 30-minute delay so that they can stop the live streaming if something happens. So I guess that in the most arbitrations where it's not about like a criminal procedure before a court, suicide is probably not likely to happen. But in any case, there are considerations that also speak against complete live streaming of proceedings. So to conclude now, actually, I started the lecture with the question, is there a trend towards ever more transparency in arbitration? And I think we could say, yes, there is a trend. But this trend, in the end, does not mean that all and everything, documents, hearings, is public all the time. But there are very sophisticated, very nuanced rules concerning the different stages and the different types of documents. However, but the question then, which is interesting for international lawyers, is, do we already have like a general principle of transparency in international and transnational arbitral proceedings? I think that we cannot say yes. There is not yet such a general principle because the existing rules are quite diverse. So we cannot say that there is an overarching general duty to make all kinds of documents transparent. However, we could say that there is at least a duty to take this into account and consider about the benefits of transparency also in international and transnational arbitral proceedings. And the main reason is, I think, that actually arbitration is not, if it has ever been, a really private matter. In the reading by Charles Brouwer that you have already consulted, hopefully, Brouwer says, this is in paragraph 5, he says there is a fundamental distinction between arbitration and judicial settlement. He says that in arbitration, the tribunal can consider only the parties as its audience, as the sole audience. And I think that this is no longer correct if we look at investment arbitration, if we look at the repercussions for consumers, at environmental impact. Therefore, I think we must at least allow the idea that there are arbitrations which concern public rights, but are still also, at least partly, in the public interest and which create public problems, and that therefore a moderate and nuanced transparency regime is adequate also in arbitration.